Now we're going to talk about administrative proceedings. This is where the government agencies are doing their own prosecutions. We talked about administrative law and the various, well, not all of them, but some of the agencies or examples of agencies that prosecute and oversee those laws. This is the procedure that takes place. So when an agency determines that one of its laws or regulations has been violated, what it will do is it will serve a subpoena or an order requiring that alleged violator to appear at a hearing. And this hearing is like an informal court trial. There is a judge. They call that person an administrative judge or a hearing judge. There is no jury, and the evidence or the information that comes in can be a little bit more laxed in this arena. The standard of proof, so we had with our civil cases preponderance of the evidence. That's the lowest standard possible. And then we had criminal prosecutions, which was beyond a reasonable doubt, which is the highest level standard of proof. So in these administrative proceedings, the standard of proof is clear and convincing evidence. So it's it falls between those two standards. It's a higher standard than preponderance of the evidence, but it's a lower standard of to reasonable doubt, beyond a reasonable doubt. So that's the standard that the government agency has to get over. They're the ones bringing the proceeding. I don't have it up here on the slide, but I do want to make note that the person who brings the case is the government agency. They call that the petitioner. And in the person who is the alleged violator is called the respondent. So we have petitioner, respondent. In the civil case, we have the plaintiff and the defendant. In a criminal case, we have the prosecutor or the people versus the defendant. So there's a little bit of different terminology there. So parties are referred to as petitioner, the agency, and respondent, the violator. If the respondent is not successful, they can appeal. There is an appeal process that's built into the administrative proceeding, and that process is an appeal board of the agency. So the person doesn't get to go to court yet. So they have their hearing before an administrative law judge. If they lose, they can take their appeal up to the appeal board within the agency. If that appeal board determines that the judge, again, they're looking at errors made by the judge, which could ultimately affect the judge's decision. If the appeal board finds that there was an error, the only recourse that the appeal board does is send it back to the judge for a new hearing. If the appeal board affirms or agrees with the administrative law judge and keeps the decision the same, at that point, the respondent can take their case to court for review. The court will look at the case to see, one, that this person has exhausted all of their administrative remedies, meaning they worked their way up the chain in the administrative process, going from the hearing to the appeal board, and any other avenue that might be required for the particular administrative agency. But for general purposes, it's normally the first hearing and then an appeal board and then the ability to go to court. But the court does not review the entire case in its whole. It only looks to see if the judge acted or the board acted arbitrarily and capricious. So that, again, is a very tight standard. And the only recourse, the only thing the court can do is toss it back to the administrative agency. They can't say, I'm going to change this decision. If they feel that the decision was made arbitrarily and capricious, meaning there's no real basis for it, they throw it back for a new hearing and a new proceeding. So that's how the administrative proceedings work generally. And I'd like to, before I go into alternative dispute resolution, I want to share an example of a case involving a civil, criminal, and administrative proceeding all in one. And you may have heard about Volkswagen. They had a big no-no the big case. They were dubbed the Diesel Dupe. It was discovered actually by students at I think it was the University of West Virginia. They were doing tests. They were testing cars on emissions, and they were thrilled by the idea that Volkswagen was putting out a vehicle that was emitting very low emissions, very environmentally sound. So they started testing the car. They're like, wouldn't it be great if all our cars were like this? Let's see what they're doing. So they kind of reverse engineered the car. And they realized that the car was not doing what it was supposed to. Actually, many of the VW cars being sold in the US had a defeat device, as they called it. It's kind of software that would trigger when it was being tested for performance by the United States government. And what would happen is it would cheat the emission tests for the US. So they built this device that they were able to determine, have the ability to cheat the emission tests in the US. But when these students kind of reverse engineered it and took it apart, what really happened was it was emitting, the emissions were well off the charts, beyond the standards of the US. And the EPA got involved, the Environmental Protection Agency got involved, filed a violation against VW, and the whole thing kind of fell apart from there. The Federal Trade Commission got involved for unfair trade practices, product deception. Who else was involved? The U.S. Custom and Border Protection, claims of customs fraud, the Financial Institutions Reform Recovery Enforcement Act, that organization or that agency got involved. All of these government agencies came to a head and brought administrative proceedings against VW. In return, or not in return, I should say, also, the FBI got involved and was investigating VW and the executives and the employees of US VW. There wasn't much they can do with the folks in Germany, and the German government was taking responsibility, or was doing what they needed to do to go after the folks in Germany running VW. But for US, the FBI got involved and charges were brought for conspiracy to defraud the US and the US Customs and violating the Clean Air Act by misleading the EPA and US customers about the vehicles. So that's our criminal case. So we have the administrative proceedings going on, criminal cases and criminal charges are being brought against executives and employees. And then on the flip side of that, class action lawsuits, civil lawsuits in the form of class actions were being brought by consumers, people who bought the Volkswagen based on their claims. So all of this is going on. So you can have all of these, one set of circumstances in several different kinds of cases. So ultimately, VW pays out $1.5 billion in the administrative cases. They pay out $2 billion in the criminal cases. They paid out $15 billion in the consumer class action suits. So they had to take back cars and reissue refunds. So very big case. Big company going down, not the first one. I'll probably bring up some others along the way in this course. So one more component of resolution that doesn't involve people going to court. We call it alternative dispute resolution, and there's three different avenues here, three different things that individuals can do. Formal, some of these are formal. Actually, one of them is formal. Arbitration is formal. The other two are kind of informal, the negotiation and the mediation. Because litigation and lawsuits, they're long, they're expensive, and maybe sometimes we can resolve this issue if more people are ready to, parties are ready to come to the table and talk. So let's talk about the different three here. We have negotiation. And this is when the parties just come together. They attempt to settle a dispute without going to court. Sometimes they'll get attorneys to talk to each other an attempt to settle a dispute without going to court, but ultimately what happens is somebody ends up threatening to go to court. But parties have used attorneys to negotiate. They've used each other to negotiate. They may pick somebody within their company to go and negotiate. Mediation is another form. Negotiation, by the way, is probably the cheapest route to go. Mediation, this is the use of a neutral third party to facilitate a settlement. This is not adversarial. This is not litigation. A lot of small claims courts highly recommend this process first. As a matter of fact, Plattsburgh City Court requires individuals who have small claims cases to use a mediator who goes to court twice a month. I actually used to be a mediator. I'm a certified mediator. I used to do that in city court where I tried to facilitate settlement. It's not about picking a side or making a decision as a mediator. What the person does is they act as a communicating agent, works with both sides of the dispute to kind of come to a resolution. They talk with the parties, they emphasize the points of agreement, help kind of evaluate options. They may propose a solution, but that doesn't make the decision or resolves the matter. The parties get to decide what the resolution is in a mediation. And sometimes they reach a mediation or an agreement, a settlement in mediation, and sometimes they don't. Arbitration. This is more formal. Again, a neutral third party. It could be one person. Sometimes it's a panel of experts. Sometimes it's an attorney or a group of attorneys. This is kind of like a mini trial where someone actually makes a decision. The arbitrator will hear a dispute and impose an actual resolution on the parties. So it's kind of, like I said, like a little mini trial with a judge. The parties usually agree that the decision will be binding on them, but it does not have to be. So parties could say, yeah, I'm still going to go to court. Some examples of this is actually, this is an example of binding resolution. Binding arbitration is New York State's lemon law. They call it lemon law for the cars. Somebody sells a used car or a new car and it doesn't operate right. I'm saying that very generally. We call that lemon law. There is a state statutory mandate that those get arbitrated. And I've arbitrated a few of those, but those are binding decisions. You see a lot of provisions in contracts regarding arbitration, especially in many business contracts. If you see them in mortgages, you see them in secured transactions. You've probably, if you dove into the terms of use of Amazon or any of the social media sites before you can sue any of those outlets, there's probably an arbitration provision where you got to go to arbitration first. The decision of the arbitrator is called an award. It's not called a decision, it's called an award. So when an arbitration is binding, a party can ask a court to review that decision, kind of like an appeal. A court can toss out the award only if the arbitrator's conduct was in bad faith or was in prejudice to a party. So again, the threshold isn't en blanc, carte blanche, I should say, for arbitration. It's very much like the administrative proceeding. Courts' hands are tied with what they can and cannot do. So if it's binding arbitration, the party gets court review, but it's a very tight ring on the judge, right? Handle bad faith. If the arbitrator acted in bad faith or prejudiced the party, it will get tossed out. We're seeing a lot of online dispute resolution. Basically, this is a resolution of a dispute via the internet. They're done in online forums, and usually they're for disputes involving transactions that happen over the internet. The quality of goods or items that were sold on the internet, things on online auctions. Domain name disputes is an online dispute resolution. There's a forum for that. You don't automatically doesn't automatically apply the law of a special jurisdiction. The state's going to use, what's going to happen is there'll be what they call universal principles, but kind of what's fair. when they say universal principles. It's kind of what's fair in online dispute resolution. And you can appeal to a court anytime off of the online dispute resolution, considering jurisdiction. Online dispute resolution might work if you're using, if it involves maybe an online business who's not in the U.S. Maybe an online dispute resolution is the way to go. So those are the alternative dispute ways to the ways that we have where parties can alternatively resolve their cases. And with that said, that's the end of this discussion. And the next section will be contracts.